Okay, so in yesterday's hearing, Ro Khanna clearly said that the FBI is working under pressure from the current administration. So the question is simple. If the files are public, then why are there still so many redactions? Did the Department of Justice simply upload whatever the FBI sent them? And if the FBI had already scrubbed the files, then what does transparency really mean? This is not just about one case. This is about the process. Is the system working differently for powerful people? Or is there truly one system of justice for everyone? First, we will watch Ro Khanna's clip, then we will break down the full story step by step. Stay with us until the end of the video.
Yesterday, Congressman Massey and I went to the Department of Justice to read the unredacted Epstein files. We spent about 2 hours there, and we learned that 70 to 80% of the files are still redacted. In fact, there were 6 wealthy, powerful men that the DOJ hid for no apparent reason. When Congressman Massey and I pointed this out to the Department of Justice, they acknowledged their mistake, and now they have revealed the identity of these 6 powerful men. These men are Salvatore Navora, Zorab Mikaladze, Leopig Leonor, Nicola Caputa, Sultan Ahmed bin Sulayem, CEO of Dubai Ports World, and billionaire businessman Leslie Wexner, who was labeled as a co-conspirator by the FBI. Now, my question is, why did it take Thomas Massey and me going to the Justice Department to get these 6 men's identities to become public? And if we found 6 men that they were hiding in 2 hours, imagine how many men they are covering up for in those 3 million files. But the story gets worse. The reality is that Donald Trump's FBI scrubbed these files in March, long before Thomas Massey and I passed the Epstein Transparency Act. Now, my bill is clear. The Epstein Transparency Act requires them to unredact those FBI files. And yet the Justice Department said to me and to Congressman Massey, we just uploaded whatever the FBI sent us. And guess what? The FBI sent scrubbed files. That means the survivor's statement to the FBI, naming rich and powerful men who went to Epstein's island, who went to his ranch, who went to his home and raped and abused underage girls or saw underage girls being paraded, they're all hidden. They're all redacted. It's a little bit of a farce. They're inviting all the members of Congress to go to see the Department of Justice, quote unquote, unredacted files, but they've got all redacted files from the FBI. And it's not the fault of the Justice Department attorneys. They were just told upload things that Donald Trump's FBI had already scrubbed. It's a blatant violation of the Epstein Transparency Act, but it also asks a fundamental question. Who are they protecting? Why are they protecting these rich and powerful men, people I call part of the Epstein class? Why are we in a country where there is no elite accountability for people who do the most heinous things? You have in England the king now calling for an investigation and possible prosecution of his own brother. You have in Norway the princess who no longer has support to be the queen. And yet in the United States of America, we have someone in the cabinet, Howard Lutnick, who is all over these Epstein files, who allegedly had business with Epstein after he was convicted of pedophilia, and he still is in the cabinet. We need to ask ourselves, are we in America going to have elite accountability? Are we going to call on rich and powerful people who broke the law or cavorted with a pedophile, a convicted pedophile? Are we going to call them to account? Are we going to have prosecutions for billionaires who went to this island and either raped underage girls or saw underage girls being raped and didn't say anything? Are we going to have investigations? I'll tell you what this is about. It's not just about the 1,200 survivors. It's about 2 tiers of justice in America. It's about people who can accumulate wealth and power and don't have to care about the rest of America. They have destroyed so much of this country. Income inequality is at a 60-year high. Workers' salaries are less than they have been for 75 years as a part of GDP. Somehow this country seems to be working for the rich and powerful, but it's not working for ordinary working class Americans. I say enough. It's time to begin with accountability for the Epstein class. Hold them in front of Congress, those people who visited the island or did business with Epstein after he was a convicted pedophile. Investigate them, prosecute them, and let's return to democratic accountability in the United States of America. Let's return to one system of justice in the United States of America. Let's return to a place where every American has a stake in this country.
Now, after watching Ro Khanna's clip, the first question is about process. He argues that a large portion of the Epstein files remain redacted and suggests that the FBI may have scrubbed the documents before they were shared. To understand this properly, we need to look at how the federal system actually works. In the Epstein case, the Federal Bureau of Investigation was the primary investigative agency. The FBI collects evidence, interviews witnesses, gathers digital records, and maintains investigative files. The Department of Justice oversees prosecution decisions and determines what material can legally be released to the public. When documents are released in high-profile federal cases, they are not published as raw investigative files. They go through legal review. Certain categories are automatically protected under federal law. These include grand jury material, information related to ongoing investigations, identities of minor victims, confidential witnesses, and privacy protections under the Freedom of Information Act. These redactions are not optional. If the Department of Justice releases protected information, it can violate federal statutes. The key question, however, is whether the redactions in the Epstein files are standard legal redactions or unusually extensive ones. Publicly available court records show that even during the original 2019 federal charges against Jeffrey Epstein, many documents were sealed or partially redacted. Later, civil litigation led to additional materials being unsealed, but courts also clarified that the appearance of a name in a document does not automatically imply wrongdoing. Ro Khanna's central argument focuses on transparency. His position suggests that if the files are presented as unredacted but still contain significant blacked-out sections, then public expectations may not match reality. At the same time, the Department of Justice has historically maintained that it releases only what is legally permissible. If the FBI removed certain identifying details, victim statements, or sensitive investigative leads, that may reflect statutory compliance rather than concealment. Another important factor is the federal grand jury secrecy rule under Rule 6E of the Federal Rules of Criminal Procedure. Grand jury materials are generally prohibited from public disclosure unless a court authorizes it. A significant portion of investigative material in cases like Epstein's can fall under that protection. So when allegations of file scrubbing are raised, the implication is political pressure. However, as of now, there is no publicly documented court finding that establishes political coercion behind these redactions. That does not eliminate public skepticism. The Epstein case has long generated distrust, especially following the 2008 plea agreement in Florida, which was later criticized and reviewed by federal authorities. High-profile cases involving wealthy and powerful individuals often create intense public demand for full transparency. Under FOIA law, exemptions allow agencies to withhold information related to privacy, law enforcement methods, confidential sources, and ongoing proceedings. These frameworks have existed for decades and apply across administrations. If redactions were unlawful, the ultimate test would be a judicial ruling ordering additional disclosure. Until such a ruling occurs, the official legal position remains that redactions are based on statutory requirements. This means the debate now centers on trust. Ro Khanna frames it as an accountability issue and questions whether powerful individuals are treated differently. The Justice Department frames it as a legal compliance issue governed by federal rules. The facts that are publicly confirmed show that documents have been released with redactions under established legal standards. What has not been publicly confirmed is documented evidence proving political direction to conceal specific names. So the broader issue becomes confidence in institutions. Is the public receiving all information that can legally be released, or should Congress pursue further review to ensure transparency? Those are legitimate oversight questions, but they remain questions, not established findings. If you found this breakdown useful and want more fact-based analysis that separates claims from verified evidence, make sure to subscribe to the channel. We focus on documents, process, and public record, not speculation.